500 U.S. green card holders are currently stranded at Dubai airport, and an American-born child has just been deported. Under Trump's new green card policy, even if you've lived in the U.S. for decades, even if you're traveling briefly to visit family, without pre-travel approval, you can be denied re-entry.
Attention green card holders, stop being afraid to travel. It is impossible. No way, no how. Your green card cannot be revoked at the airport.
Yes, people with valid green cards are being denied re-entry to the U.S. Same for H-1B visa holders, asylum seekers, and even Canadian professionals with legit TNS paperwork.
If you're a permanent resident or green card holder, you are not subject to the travel ban, but conditional green card holders are subject to the travel ban.
Might like that green card holder doesn't have an indefinite right to be in the United States of America, right? American citizens have different rights from people who have green cards, from people who have student visas.
Breaking news. Over 500 U.S. green card holders are currently stranded at Dubai airport, and an American-born child has just been deported. Under Trump's new green card policy, even if you've lived in the U.S. for decades, even if you're traveling briefly to visit family, without pre-travel approval, you can be denied re-entry. Even immediate relatives of U.S. citizens are being turned away. Dubai airport is now the first flashpoint. Protests erupted on site. Some were forced to reroute to third countries. Others remained stuck for more than 30 hours. But the deported child's case is even more alarming. He's 8 years old, born in America, holds a U.S. passport. But because his mother's green card wasn't pre-approved, both were denied entry. The immigration officer gave them two options. The boy could stay and be placed in foster care or leave the country with his mother. They chose to leave. Green cards are no longer safe entry permits. They're becoming fragile labels that can be revoked at any moment.
Green card holders are being stopped. Some are being deported. Even valid visa holders are getting turned away. What's actually happening? We're seeing more cases where lawful permanent residents, yes, people with valid green cards, are being denied re-entry to the U.S. Same for H-1B visa holders, asylum seekers, and even Canadian professionals with legit TNS paperwork. Even a Canadian actress was detained and denied. This isn't rumor. It's happening. Why it's so risky in 2025? The current administration is tightening borders, making it harder for anyone who isn't a U.S. citizen to return once they leave. Even if you followed all the rules, there's no guarantee you'll be let back in. And if you're stuck, you could lose your job, your visa, or even be forced to start over. My honest advice: if you're not a U.S. citizen and you can't afford to be stuck outside the country for 6 to 12 months, don't travel right now, unless it's absolutely necessary. This is about protecting your future, because once you leave, you're taking a risk, no matter how valid your paperwork is. That's the strategy. Keep people scared. Keep them from moving. Don't fall into the trap. Stay informed. Stay grounded. And if you want more real updates like this,
Attention green card holders, stop being afraid to travel. It is impossible. No way, no how. Your green card cannot be revoked at the airport. The only way your green card gets revoked is if you give it up voluntarily. So you got to know your rights. And the number one right you need to know is you have the right to see an immigration judge, and only an immigration judge can take your green card away. When you come into the airport, the CBP officer, if they want to be jerks, are going to try to get you to sign a piece of paper that you voluntarily give up your green card. No matter what they say to you, you don't sign it. And the only reasons that you would ever have a problem re-entering the United States is if you have a criminal record. You're a suspected terrorist. You have stayed outside the United States for long periods of time, and you are generally using your green card to come visit but not living in the United States. Or you have committed some form of fraud. The only difference between now and back then, when you felt safer to travel, is that maybe CBP is asking a few more questions, and maybe CBP is trying to twist your arm to get you to give up your green card. Otherwise, the laws are all the same. They have not changed. It's the same law from 2021, 2022, 2023, 2024, and now in 2025.
Green card holders are not being allowed entry into the United States and they're being deported. H-1B visa holders, same deal. People who had valid asylum claims were allowed to stay are now not being allowed into the United States. Canadian actresses are getting their TNs denied and thrown into detention. Well, as an old immigration attorney who's been practicing law since 1997 and has been practicing immigration law since 2007, I believe that unless you are a U.S. citizen, you should not leave the United States unless you can afford to be stuck outside the United States for more than 12 months. All these people are getting stuck. They're having to start over. It's a big old pain, and that's what the Trump team wants. They want you scared. They want you not coming. And unless you can afford to be stuck away from the United States, away from your job, away from your family for 6, 8, 9, 12 months, you should not leave the United States unless you're a U.S. citizen.
Green card holders with the travel ban. Let me tell you what you need to know. So we have here green card holders and we have conditional green card holders. The travel ban treats them very differently. If you're a permanent resident or green card holder, you are not subject to the travel ban, but conditional green card holders are subject to the travel ban. Let me give you an example. Let's say you're from Haiti and you got a green card through marriage. Your green card is good for only 2 years, and then you need to go through the process of getting a permanent 10-year green card. So you are a conditional green card holder. If you have a 2-year conditional green card and you're from Haiti and you leave the United States, according to the travel ban, you would not be permitted to come back in the United States. On the other hand, if you're Haitian and you have a 10-year green card, the travel ban wouldn't apply to you. Got it?
Laura, a green card holder, even if I might like that green card holder, doesn't have an indefinite right to be in the United States of America, right? American citizens have different rights from people who have green cards, from people who have student visas. And so my attitude on this is, this is not fundamentally about free speech. And to me, yes, it's about national security, but it's also more importantly about who do we, as an American public, decide gets to join our national community? And if the Secretary of State and the President decide this person shouldn't be in America and they have no legal right to stay here, it's as simple as that.
Do you see more such deportations happening?
I think we'll certainly see some people who get deported on student visas if we determine that it's not in the best interest of the United States to have them in our country. So yeah, I don't know how high that number is going to be, but you're going to see more people.
The client was flying back from Trinidad to JFK Airport. She had been outside of the United States for about 11 months, and prior to that, she had been outside of the United States for about 9 months because she goes to school in Trinidad. Now, she has a lawful permanent resident card, and when she hired us, I told her, hey, you need to get a reentry permit because you can't be outside of the United States this long. With the reentry permit, aka the white passport, it allows you to be outside of the United States for a 2-year period. So she was coming back to the U.S. to allow us to apply for that reentry permit because your physical body has to be in the United States when you make this application. When she arrived at JFK, she was placed into secondary. She had her cell phone on her, and during her whole experience she was messaging me, and the CBP officer was questioning her why she was outside the United States, and she had her school documents and she was explaining why she was outside, but they kept telling her you're not allowed to live outside of the United States with your green card without a reentry permit. And they kept telling her, I want you to sign this I-407 abandonment, a lawful permanent resident status. And if you sign it, we'll let you in for a couple weeks to visit your family, but then you go back to Trinidad. And I kept telling her, don't sign it, don't sign it. If you sign it, that's it. You've given up your green card and you're not going to get it back again. You're going to have to find another way to get your status. Don't sign it, don't sign it. And after being detained for 5 hours, they were like, fine, here's your green card back. Go and apply for your reentry permit. And they released her back into the United States from the airport. And now we're going to be able to file for her reentry permit. The point is that you need to understand what goes on at the airport, how much control and power CBP has, and they're going to try to trick you and they're going to try to force you to sign things. Don't sign anything unless you fully understand what it is that you're signing. An I-407 has a severe consequence. It literally means you're giving up your resident status. Luckily, I was on standby and we had full conversations while she was at the airport and was able to save her. And now she has her green card still, and we can just go ahead and apply for her reentry permit.
Is ICE actually detaining people at the US airport even though they're a green card holder? Please, let's get into this right now, because I really hate when information is spread incorrectly, and I want you to understand everything responsibly. My name is Mamita Rahman, and I'm an immigration attorney who's been practicing immigration law for the past 15 years. Here is really what's going on. CBP has always had the right to have people sign a piece of paper called the I-407 Record of Abandonment of Residency. I think that's the proper title, but what this is that if you are a green card holder who is returning to the United States and you're going through a port of entry and you have been out of the United States for at least 6 months, then basically your absence from the United States of 180 days plus basically allows CBP to question you further to determine whether or not you have abandoned your residency. Now, if you are a permanent resident of the United States, then having actual residency here in the US is a requirement, which is why if you leave for more than 180 days in one single trip, it basically triggers a rebuttable presumption that you have abandoned your residency. So henceforth, when people return from abroad, a lot of times, if they have been out of the country for more than 180 days, Customs and Border Patrol can definitely ask you questions about your residence, about whether you have any ties to the US. And many times, they will actually pressure you to sign this form called the Form I-407, Abandonment of Your Residency, which basically gets you to give up your green card without seeing a judge. So what should you do if you are a green card holder returning from abroad and you run into problems with CBP because either this or something else? Demand to see a judge. Demand to see a judge. Do not sign anything without a lawyer, and exercise your right to remain silent if you do see that they are detaining you. Now, if you do sign that piece of paper, then it's going to be very hard to prove that you did not give up your residency. But if you go in front of a judge, then you at least have the right and the ability to prove that you did not give up your residency. And also you basically get to, you're going to be allowed into the United States as well. So let's all take a step back. I know that the times are very scary. It's easy to believe a lot of things, but it's also very easy to misinterpret the news. And I hate to say it, I see some of my fellow attorneys spreading things and causing panic as well. And one more thing that I want to mention is that if you are a green card holder who has any sort of criminal history, this can also be a problem. And this can be such a problem to the extent that we advise our current clients, if they have any sort of criminal issue, to avoid travel or at least get the charge checked out before they travel. Because also, if you have been out of the country for more than 6 months, if you have certain criminal issues, CBP will use that against you and can use that against you. Also, they can use this against you even if you have been out of the country for less than 6 months. So if you do have any sort of criminal history, even if it's been dismissed, you do want to get this checked out and get it verified by an attorney who understands the intersection of law between criminal law and immigration law, which we call crimmigration in attorney parlance. This is something that needs to get checked out as well, okay? Again, my name is Mamita Rahman. I'm an immigration attorney who's been practicing immigration law for 15 years.